All right. Well, good morning. Thank you all for coming. Want to introduce my good friend, Jeff Kichaven from California.
Good morning.
Came here for the weather, so thank you for joining us from Beverly Hills. You've all received the materials about why we're here today, but maybe it's a little bit of background as to kind of what led to this event. As a lot of you know, a lot of my practice involves court appointments, either at the magistrate level or the discovery facilitator. That is ensued to some mediation and ADR work over the past couple of years. I just knew that I needed more training. So I went and did some training at Harvard and Pepperdine, got done that, knew I needed more training. And so I looked up this group called the International Academy of Mediators and was thinking about, well, how can I continue to get more education so that I can actually do this job in a serviceable manner? Looked up some of the fellows, found Jeff in a lot of articles. I reached out to him just to ask him about what it's like and just to pick his brain. And he generously said, well, I'd be happy to sponsor you. So Jeff's idea to sponsor me has led to a relationship and a friendship, and he's been mentoring me in the process. And it was his idea to come to Delaware and to put on this presentation. So we really thank Jeff and his wife, Liz, for coming in from Beverly Hills to join us on a cold December morning.
Cold? What are you talking about? There's no snow on the ground. It's springtime.
Well, we appreciate the optimism. So Jeff is, just real briefly, he is a graduate of Berkeley and Harvard Law. He had 20 years in private practice, first at Alschuler, Grossman and Pines, and then Pregerson, Richmond and Luna. And as you saw from my email, he is a Band 1 nationally ranked Chambers mediator. So we're very fortunate here to have one of the best in the business to talk about kind of mediating the disputes that all of you practice and litigate. So Jeff, maybe tell me a little bit now about your practice and your firm.
Well, thank you, Ryan. It's a delight to be here. Thanks to all of you for coming, and Wilmington Club for these beautiful facilities, and to you and your law firm, Ryan, all your colleagues here for establishing this so beautifully. It's just great to be here. So my practice now, I'm an independent mediator in private practice, and through the miracle of Zoom, I'm now able to have an international practice and handle cases that I never could have handled before. As Liz knows, many of them either begin at 5 a.m. or 5 p.m. when we have people in different time zones all around the world. I do a lot of intellectual property cases. I do a lot of insurance coverage cases, and a wide mix of business-to-business cases of every shape and size. Most of them involve high-end lawyers such as yourself, sophisticated parties, emotional complexity, legal uncertainty, the factual situations one could never, ever imagine. And sometimes I think I've seen it all after having been a full-time mediator for 28 years, and then the next case rolls in the door, and I realize it's something completely different. And that's part of the beauty of the practice, having something different to work on every day, and being able to work on those cases with highly skilled lawyers, business executives, and negotiators makes my professional practice a dream come true. And I'm delighted to share some thoughts with you, and I hope that many of you will have questions, and we'll try to address ourselves to the issues and concerns that are most on your minds.
Absolutely. So what type of practice did you have prior to transitioning to be a full-time mediator?
It was financial litigation, business-to-business litigation, a lot of securities litigation, a lot of partnership disputes. It was all business-to-business cases. And I did that for the first 15 years at a firm called Alschuler, Grossman and Pines. We had a very fine relationship with the Wachtell Lipton firm in New York City, and they would bring us in on their West Coast cases. So got a taste of very sophisticated securities and corporate litigation through that. And then, of course, the sophisticated economy we have in California, intellectual property cases, a lot of copyright-related cases, other sorts of financial and business cases. So it was a sophisticated commercial practice. Then the firm hit on a very large contingent fee, and many of us were able to take a hard look at what we were doing in life and maybe get off the path of least resistance, on which you get good grades, you go to a good college, you go to a good law school, you get in with a good law firm. All of a sudden, you've got a wife and a dog and 3 kids, and there you are humming along in life, and you're just wondering, what do you really want to do? And when we hit on that big contingency fee, and I got several years' income at once, it gave me an opportunity to take a more mature look at what I was doing and realize that, well, maybe being a litigator wasn't for me, and maybe being a mediator was more consistent with my personality and outlook. And because I had the benefit of that contingent fee, I had the financial cushion that was necessary to begin the mediation practice, do it in an orderly way. And that's almost 30 years ago, and I've never looked back.
Well, that's wonderful. So you spent about 20, 21 years in private practice. A lot of mediators have spent some time on the bench. You did not. So tell me a little bit about your approach to mediation and how you may approach things differently than a lot of other mediators that we may have come across with.
Yeah, thanks for asking about that, Ryan. In terms of approach, it's really a question that's better answered by the people with whom I work. Every case is different, and I try to design every mediation specifically to meet the needs of the people and the situation with which we're faced on that day. That's why I like getting mediation briefs from people at least a week, hopefully more like 2 weeks before the mediation. And then that gives me the opportunity to talk to people on the phone and find out. You mentioned I live in Hollywood. Liz spent many years as in senior positions in motion picture and television production. We're looking for the backstory.
Sure.
We want to know what's their motivation. We want to know things like that. Because when you get into the human elements of it, that's when you can really make a difference. That's when you can really design a process that will not only get a case settled, but will get a case settled in a way that satisfies the human needs of the participants to feel understood, to feel acknowledged, feel recognized. We want to give people an opportunity to participate in the fashioning and the formation of the settlement. And then that way they're more satisfied with it when it actually occurs.
Right.
So figuring out the right set of communications, customizing every case, critically important to the success of the mediation.
Yeah. Well, maybe as a matter of intellectual property law, I should admit that I've stolen one of your themes, which is the successful business resolution, business settlement comes from an exchange of information. And I think that's one of the things that you've taught me and you've demonstrated in your practice, that having that share of information, allowing a business person to decide what the best alternative is that day, be that to litigate further or to reach some sort of compromise predicated upon the exchange of information, allows them to make the best choice for themselves. And we'll talk about the process that you employ.
Well, when you get down to it, Brian, there's essentially only 3 things we do in a mediation. We're establishing rapport and relationships, we're exchanging information, and we're bargaining. Those are the only 3 things that really take place in mediation.
Right.
And in every case, you need a different mix and match. If you're mediating early in the life of a dispute, you may need to spend more time exchanging information. If a lot of discovery has already taken place, then there may be more time spent on bargaining. A lot of mediators and a lot of people in general overlook that first part, though, which is establishing the rapport and establishing the relationships. Because as you go through the litigation process, so often you're just demonizing the folks on the other side. They're the big bad evildoers. And you forget that at one point you might have had a very productive, collaborative business relationship with these people. You may have personally liked the people, and then things happen. So if we can do things to try to defuse that demonization and rehumanize people in each other's eyes, that sets the stage so beautifully for exchanging the information that you need and ultimately efficient bargaining that leaves people happy with the result.
Yep.
I don't believe that a good mediation is one in which everyone is equally unhappy. I don't know about you, but I didn't go to all these.
I've stolen that one.
Yeah, go right ahead. Go right ahead. And I hope you all steal these lines because We didn't go to all these fancy schools and work hard all these years to have a career in which our goal is to make people unhappy, albeit in equal degrees.
Right.
Well, how is that a life? Is that a career? No, people will always, the ones who pay money are always paying more than they think they should. The ones who are getting money are always getting less than they think they should. So there's always that degree of disappointment with the financial term of a settlement. But the settlement encompasses so much more. There's also, no offense, but not having to pay legal fees anymore. There's also having the emotional burden and the time suck of being involved in litigation, having all of that lifted from you, the ability for your clients to get on with their businesses and get on with their lives and careers. All these other dimensions of the settlement are fertile ground for client satisfaction. And if the utility that people get from these other dimensions outweighs the disappointment they will inevitably feel with the financial term, then by definition, it's a good settlement.
Right.
Because the utility outweighs the disappointment in the financial term. And if the utility or benefit outweighs the disadvantages or disappointment, then you're leaving people better off than they were before. And if people are better off than they were before, I think that's a pretty good working definition of happiness for purposes of.
No, absolutely. And I think one thing you touched on, we often lose sight. I know that I've done that when on the litigation side of mediation, right? When I'm representing a party, it's hard to remember that there is an emotional element to it. And like you said, when you come to mediation, you're often entrenched in dispute, right? That's why you're there. And we all know each other. One of the nice things about the Delaware bar is we tend to be a collegial bunch that can meet on a random Wednesday and break bread. Clients don't always have that same fondness for each other at that time. And as you said, the ability to hire somebody who's not going to browbeat you and to actually help you facilitate the exchange of information and say, you know what, here's the reasonable position that I'm hearing from the other side. That takes the burden off of the attorney to do that with their client and gives them that third indicia of like, oh, maybe there is a reason here.
Well, yes. And one of the hidden secrets of mediation is that in many cases, the most important thing that we do as mediators is help excellent lawyers break bad news to their own clients. It can be very difficult as a lawyer to turn to your client and say, the case is just not panning out the way we thought it would. And the witness didn't testify the way we thought the witness would. The judge hasn't ruled the way we thought the rulings would come down. Case really has some trouble. And I'm sure you've all been in situations where you've tried explaining that to your clients, and in the privacy of your office, your client turns to you and says, oh, Ryan, we know the case has big troubles. That's why we hired you. And that can be kind of a show-stopping discussion. What is a lawyer supposed to do in the face of that? Well, one thing that you can do is to bring a mediator in, because it is much more difficult for a client not to take seriously the gravity of the issues with the case in the presence of a third party. Sometimes as mediator, all we have to do is sit in a caucus, listen to the Ryans of the world explain to their clients some of the pitfalls, weaknesses of the case. And as mediators, sometimes all we have to do is nod, furrow our brows appropriately and go, he's right. Yes, that he's right. That is what's going on in the case. And oftentimes that can have the effect on the client of getting the irrational exuberance out of the air and getting the clients to look at the case in the balanced way, the 360-degree way that you've been urging your client to employ. And if we can help you maintain that relationship with the client and that rapport with your own client and restore and heal communications with your own client, that's one of the true benefits, unheralded benefits of mediation.
Yeah, absolutely. We got a lot to cover today, and I want to go through mediating a complex case, talk some about specific Delaware corporate disputes and some unique things I think, to this jurisdiction. And then if we have time, we can talk about some of your tips and your best practices to handle. Before we do, just move off that. And I still do litigate, but when litigating and you receive the request to say, identify your strengths and weaknesses, I always kind of blew that off as one of the most unimportant parts of the mediation statement. Having now mediated cases, it is invaluable because it's the exercise of having the client look at the request of a neutral to identify what their weaknesses are. And when they begin to think about that, it becomes more, you enter objectivity into the process. You can tell in mediation when the attorneys have not shared that information with their client and it's just, kind of checking the box on the mediation statement versus somebody who sat down with their clients and said, hey, Kichaven, Newell, they want to know what our strengths are. They want to know what our weaknesses are. Let's talk about them. That process of beginning to think about that really does help facilitate the resolution process.
Yes, and it can often be difficult for you to express your own weaknesses.
Yes.
But it's very easy for your opposing counsel to express your weakness.
Sure.
It's their strengths. So that's why I encourage people to exchange those mediation briefs so that you can show your client before the mediation your brief and the other side's brief. The other side's brief ought to be a clear explanation of their strengths, which are by definition your weaknesses. And then you can go over that with your client before the mediation and have as open a discussion as you can. How are we going to deal with these things? Mm-hmm. Very important.
That's great. Let's talk a little bit about the complex case. In a lot of our cases where there's D&O coverage or other types of carriers involved, that's a third party that we are now injecting into the mediation process. What types of challenges or opportunities are posed when you have a carrier at the table?
Having insurance carriers at the table makes mediations challenging, and from my perspective, it makes them fun because it creates the situation where you have an insured defendant that on the one hand is looking across the table and saying to the folks, the people suing them, no liability here, please go away. And then you have that same party, the insured defendant, pivoting behind the table, looking at its insurance carrier, saying, hey. So it's an interesting situation for that insured defendant. And having insurance carriers at the table, some people choose to view it as a challenge or a problem. I view it as a great opportunity because insurance carriers do have obligations to handle claims appropriately and pay reasonable amounts when appropriate to settle covered claims. So the insurance carriers are bringing money which can be used to settle the claims, money that the insured defendants oftentimes simply don't have. So it's important for mediators to treat those insurance carriers as a fully respected party to the mediation, just as important as the plaintiff or the defendant. The insurance carriers, they have their own interests, their own needs, their own concerns, their own legal rights and obligations, and mediators have to understand those as thoroughly as we understand what's going on in the actual liability dispute. The coverage dispute deserves equal respect. So we like to get briefs from the insurance carriers. What are their positions? Have telephone conversations with the carriers. Make sure that everybody understands before the mediation what the role of the carrier is, how involved they do or don't want to be, degree of participation they want to have. We want them as fully enrolled in the process as possible because their participation is oftentimes key to whether the case is going to settle or not.
Right. And I think we've all had the mediations where the mediator's pounding the table and belittling people. But I think the most successful route is looking at the attorneys, looking at the carriers as an ally. They're not your client necessarily, in terms of you're not siding with them, but you're using them to help facilitate the process and using them as an asset.
Yes, well, sometimes they have good coverage defenses. And there are cases where it's appropriate for the policyholder to contribute to the settlement, sometimes not. But being able for a mediator to understand these issues thoroughly, a mediator cannot turn to an insurance carrier and hope to be effective simply by saying, this is going to cost you a lot of money to defend. You might consider that. You don't need to hire a mediator to know that. You don't need a mediator to say, if you don't pay a policy limits demand, you might be exposed to extra contractual liability. If those are the only tools that a mediator has in dealing with an insurance carrier, you're not going to be very effective. In those situations, the mediator has to understand the coverage issues, be able to participate intelligently in that discussion every bit as much as the mediator has to be prepared to participate intelligently in the discussion of the underlying liability issues.
Yeah, absolutely. I want to touch a little bit based on something you mentioned earlier, which is resolution of cases at various postures in the life of a case. What are some unique challenges or different approaches you might take if we're talking about mediating a case where little discovery has happened versus perhaps they're up against summary judgment? They've already completed their discovery and everything's on the table. How do those types of mediations differ, and what can litigators do to best prepare themselves for those situations?
Understanding the point at which you find yourself in the litigation is important for a mediator. How well developed is the case? How well do people really understand each other's factual positions? Sometimes I analogize it to a game of poker. There's 7 cards. Rarely will a poker player want to see all 7 cards before deciding whether to stay in or fold or how to play the hand. So in litigation, there's questions of how many cards do people want to see? And different people have different factual or emotional or logical needs to see more cards or fewer cards. So you have to size up every case individually. That's the critical importance of getting that briefing and having phone calls or online calls with people before the mediation to find out how comfortable are they with the factual state of the record. Do they have unanswered questions? Is there more information they need to know? And then designing your process for that day to make sure that people come to a point where they are comfortable deciding, do I hold them or fold them?
Right. And let's talk a little bit about that process, because for those who have mediated with me, I do the same thing, right? The couple pre-calls with counsel together, with counsel and their clients separately, in an attempt to get that discussion going sooner rather than later. Get the gears of your client thinking about resolution, as opposed to showing up, perhaps running into the other side on the way to the restroom or in a group session, getting your cackles up, and then having to bring them back down.
Yeah, that elevator can seem very small if they're all riding up together.
Exactly. So let's talk about some of the things you mentioned earlier. Mediation statements, you like sharing them.
And generally speaking, I think people should share the mediation statements. Lawsuits are works in progress. So the way that the case exists in your mind today is probably different than the way it existed 30 days, 60 days, 90 days, 180 days ago. So when someone says, oh, we don't need to exchange the mediation statements, we already know exactly what these people are thinking. When I get the mediation briefs from those people, I so many times say, oh, no, you don't. The lawyers' minds are active. They're always thinking of new arguments, new positions, new wrinkles and nuances. So when you exchange those briefs, you're really giving each other the benefit of the state of the art of your thinking. You're putting your best foot forward, not your outdated foot forward. So you've done good work. You've brought the case to a high stage of development. You want credit for your good work in the negotiation. The only way to get credit for the good work you've done is to make sure the other side is aware that you have done good work developing this case. getting that mediation statement to people in advance is a terrific way to do it. Better than just popping things on folks who are unprepared to receive it on the day of the mediation. You give people something in writing a week or so beforehand. If they're shocked and awed or outraged by it, well, at least they have a few days to calm down. If you're just popping everything on people unaware on the day of the mediation, you run the risk of an emotional reaction that you simply don't have time to corral. If there's additional information that you want the mediator to see in writing, things that you don't mind if your client sees, but you don't want the other side to see, something like these lawyers on the other side are in over their heads, they've never handled a patent case of this sophistication, something like that, and put that in a side letter to the mediator. Oftentimes I'll get the side letters on people's letterheads, single-spaced, and I'll get the formal exchanged mediation statement on the double-spaced pleading paper that you file with the court. So there's some visual distinction on that. And then similarly, don't be afraid to have a joint session when the mediation begins. Now, it's up to the mediator to make sure that you can do this without having a thermonuclear emotional explosion of people. And you have to make clear to lawyers in these phone calls, invaluable phone calls, Ryan, for the mediation. Look, I'm the mediator. I've seen both sides' briefs. I've talked to both sides. Here's where the rubber really hits the road here. Here's what's really keeping you folks apart. And it's issue X. So I'd like to have a joint session, not grandstanding, not showboating, not the sort of thing that you would do in front of a jury or an arbitrator or a judge. But let's just focus in. Is damages going to be the benefit of the bargain or the out-of-pocket measure, whatever the key issue is going to be. And then let's discuss that. And we'll put a time frame around it. And if things seem to be getting emotionally too hot and you think your client's getting upset, just kind of raise your eyebrow at me and I'll know to call it off. So there's a little fail-safe mechanism there. What's so golden about these kinds of joint sessions that are tailored and curated is you can then take it into a caucus that's very effective. I can be with you, Brian, in a caucus, and I can say, we were just in the joint session, and we heard lawyer X talk about his or her position on the issue of damages. And there were 3 arguments. Hadley versus Baxendale does not apply because of thus and so. What do you think about that?
I don't know.
And well, you'll have a better answer than that, I promise you. But we'll have something to say about it, and your client will be able to listen to it. To the extent appropriate, you'll have the opportunity to acknowledge that lawyer X kind of made sense, and there's something to it, what that lawyer had to say. It's a discussion about what lawyer X had to say for the benefit of your client. If we haven't had that joint session, it looks much more like an argument and less like a conversation. It's just me coming in and saying, well, you're arguing that Hadley versus Baxendale applies this way. You understand there's 3 arguments against you, Ryan. Argument number 1, what do you think of that? Well, inevitably, it looks more confrontational. It looks like the mediator is the sponsor of the argument, not just the narrator of what lawyer X had to say. And anytime a client perceives that the lawyer and his or her lawyer and the mediator are arguing, in the client's eyes, the lawyer always wins and the mediator always loses that argument. Always. Why? Because the clients understand that you are the fiduciary, you have the duty of undivided loyalty, you're really looking out for them. As mediators, what are we? We're the people there who are just trying to hammer out a deal of one type or another so we can get another notch in our belts. The client is always going to side with you, the lawyers. So it's important that we posture these communications so they don't look like arguments, so they look like conversations. Because if they look like arguments, we're not going to have the desired impact on your client, which is we want your clients to consider different settlement options than they were considering when they first got in the elevator to come up to the mediator's office that day.
Right. I remember one of the first mediations I did, I felt like I was conveying the arguments back and forth, and it felt like litigating two cases in one day with a split personality. It's very tiresome, and you're very ineffective at that. And to the litigators in the room, that's not helpful because I'm putting you in an adversarial posture with me, as opposed to that facilitated posture where we're saying, how do you respond to that point? What additional discovery might you need to overcome that argument? Things like that are very helpful. This is a great segue, Jeff, when you're talking about these sessions with the parties, with the attorneys, to kind of transition a little bit into kind of talking about some of the unique issues of Delaware. So Delaware, obviously, we're very proud of our jurisdiction with our preeminence in corporate litigation, property, bankruptcy. A lot of your commercial disputes obviously come out of here. Those disputes for this group and this audience, very complicated, very dense. When you are mediating a case, how important are the merits in those complicated disputes?
The merits are always important. And one of the differences between being a mediator and being a judge, I've always sensed that judges spend a lot of time being the traffic cop, setting dates and schedules and calendars for things and status conferences and what have you. And as mediators, we have the luxury and the joy of being able to talk about the merits all the time. That's what we do as mediators. And a settlement, in order to be satisfying to the client, has to be tethered to reality. It has to be tethered to the reality of the strengths and weaknesses of the claims and defenses. Clients, in my experience, do not simply want to compromise for the sake of compromise. They don't want to make compromises or deals that seem unprincipled. It is not settlement for settlement's sake. One of the North Star principles that I use came from my friend, the late Dr. Mark Goulston. He was a business psychiatrist in Los Angeles and sadly passed away just about a year ago. But he said that in order for a settlement to work, Jeff, it has to satisfy three criteria. It has to make sense logically, it has to feel right emotionally, and it has to be doable practically. So we have to focus on each of those in every mediation to one degree or another. In every case, we have to have some attention to the merits and make sure that any proposed settlement is tethered to the reality, even though, as we said earlier, if you're paying, you're going to be paying a little more than you think you should. And if you're receiving, you're going to be receiving a little less than you think you should. But it can't be so wildly off the mark that it seems completely untethered from the reality of the merits.
Right. The famous book, Getting to Yes, right? One of the key points is you have to have a principled basis for any resolution. It's just very difficult to persuade on a party or to your clients that they should settle for something that is unprincipled.
Or just give up.
Correct.
Yeah.
Or just give me the money because you're going to give your attorneys the money anyway, right? That's never a winner. So Delaware, especially in our Court of Chancery where we don't have juries, that influence, I think, spreads into our Superior Court at times, our District Court as well, where we may use juries less than in other jurisdictions. Obviously, our patent cases tend to have juries. And is there an approach or something to consider when you're mediating a case that is actually going to go in front of a very smart, highly skilled judge in that field, right? The Court of Chancery, renowned business judges, same with the Superior Court, our District of Delaware, some of the best patent judges in the country. What's your recommendation when attorneys are preparing for a bench trial versus a jury trial?
So when you're going before a jury, mediators have all these great tools in our toolboxes. You never know what the jury is going to do. They're highly unreliable. Anything can happen. You're casting your fate to the winds. When you have a judge who really may be an expert in the subject matter, or an arbitrator or three arbitrators who may be experts in the subject matter, the result of the case may be somewhat more predictable than it is, maybe way more predictable than it is when it's in front of a jury. And then the question is, how do you deal with somebody who has a strong case? Well, to turn to somebody who has a strong case and say, you don't have a strong case, will accomplish only one thing, and that is you will lose your credibility as a mediator. So I find that's not effective. Still, even if somebody has a strong case, there may be reasons why they want to settle anyway. And it's perfectly legitimate and often helpful to phrase the question just that way. Ryan, you've got the stronger of the case, whether it's a 55% or 75%, whatever, however you evaluate it. You've got the better case. I'd rather have your case than theirs. Let me ask you now, and ask your client, are there some reasons you might want to settle anyway? And then we get into the discussion of what are oftentimes familiar issues: the expense, the delay, and the emotional wear and tear of litigation. Those are the big three. And for those reasons, even if someone has a strong case with a more predictable chance of victory, there may still be good reasons why they want to put it behind them now.
Right. I think one thing I've seen is hearing from parties more when we have a bench trial, because we've all practiced and we've known these individuals who are now our friends on the bench for many years. We've practiced in front of them extensively. Most of us have practiced exclusively in Delaware. So we have great familiarity with those judges. It's not surprising to hear from a party, well, how do you think the chancellor or the vice chancellor or the judge is going to rule? You litigate in front of them. What do you think? Fortunately, I have plenty of wins and losses in my career, so you can always, there is still that randomness of, even on your best day, there's a chance that the law may go against you.
Right. And what's more important than the mediator's evaluation is the lawyer's own evaluation. Because if a mediator is there, again, the mediator who's trying to pound out a settlement to get a notch in the belt, a mediator's there to sow doubt and dissonance, and clients know that. So what I find oftentimes more effective is to hear from the lawyer. How do you think this case is going to turn out? How do you think this particular judge is going to react to it? And then letting a client know that you ought to take the advice of you've got a great lawyer working for you. Take the advice of the lawyer. Mm-hmm. And so the most important evaluator in the room is actually client who's making the ultimate decision. The next most important evaluator is the lawyer who has the duty of undivided loyalty. And then only in third place comes the evaluation of the mediator, which is tainted by the mediator's perceived interest in simply getting a deal done.
Right. What percentage do you give that, Renee? And I often find that to be a very helpful question in the mediation process. We feel strong about it. How strong? Like, do you win 9 times out of 10? And if it's a 10% chance, what do you attribute that risk to? And having that conversation with the parties, with their counsel, and really digging into it. And look, if you do feel 90% confident, you might want to get a trial.
There's a simple way, there's simple tools to do it. How many of you are familiar with decision trees and decision analysis that MBAs typically learn? Well, it doesn't have to be that complicated. It can simply be, you can have one node for win and lose. And then at win, you can have another node for win big, win medium, win not very much. And as long as you're realistic about what numbers you put in there, you'll see that a strong case, let's say it's 75-25, that's a very strong case, right? I'm reluctant to value anything, particularly if there's a jury, at above 65-35. But let's say you're extremely confident, 75-25, and then at the second node of win big, win medium, win small, you put a third there, what the damages are, and very quickly, with even the most rudimentary decision analysis and decision tree, you can knock down an overconfident client or you can get a client who may think we have a strong case means 90% chance of or home run day. By doing simple decision analysis like that, you can knock that down to a more realistic range pretty quickly.
Right. And hey, look, if it is 75%, you've gathered the information. Your best alternative might be keep going.
It might be. And it's not the mark of an unsuccessful mediation if people do not settle. I often say that the mark of a good mediation is for people to make a clear, strong decision in a calm, informed environment. A clear, strong decision in a calm, informed environment. Now, most of the time, maybe almost all the time, normal people with normal psychological profiles will want to put cases behind them and settle if there's any reasonable way to do so. And that's the clear, strong decision people make. But every once in a while, for whatever reason, people really do believe that they have to take the thing all the way through. It sets a precedent.
Sure.
It has collateral impact on a lot of other cases, whatever. And if that's the clear, strong decision in a calm, informed environment, then I think mediators should respect that. And that too can be a very successful mediation.
Right. And I think an important caveat here is we're not talking about using mediation for an ulterior purpose, such as getting cheap, informal discovery about the other side. It's rather making that business decision on that day when it comes time to figure out, am I going to litigate or am I not? That's what the benefit of.
So, that question of cheap, informal discovery is a fascinating question, because how many times have all of you heard clients, perhaps within your law firms, discussions among yourselves say, discovery is just too expensive? How many of you have been participating in the discovery is too darn expensive? Well, in mediation, we can make it free. And what do you know? People complain about that too.
Right.
So in the exchange, if we can short circuit a lot of discovery and give people the information that they need that afternoon without forcing them to go through months of depositions and whatnot, well, I view that, generally speaking, as a benefit, not as an ulterior purpose or ulterior motive.
Right.
I think it can be very positive if we exchange information, then people can maybe percolate on it for a little while. And then after the onslaught of information and a mediation, maybe a week or two later, you follow up. Sometimes you need another mediation session, and then you get it settled. So I'm all in favor of exchanging information.
Yeah, I think really what it is parties feel that they're conceding the waterfront when they look like they're willing to settle and that they're willing to be more, and they're worried that comes back to bite them down the road. And I think one thing we can always remind our clients is their true weakness is really when you just take a bad deal, right? And no one there is going to force you to take a bad deal. That's not what a good mediation should do.
And part of your due diligence on mediators should include, is it the kind of mediator who values settlement for settlement's sake?
Right.
Or this clear, strong decision-making? Because the risk, if the mediator is unduly attached to settlement for settlement's sake, is that the mediator will put undue pressure on the more reasonable party. Now, let me ask the group here, when you're involved in negotiations, how many of you are typically the more reasonable party? Yeah, everybody. So if you don't want to be put under undue pressure because you're the nice guy, you're the reasonable party, ferret that out in your due diligence on mediators. What does the mediator view the goal of the mediation as being?
Right. Well, that's great. Well, we got about 10 minutes, so we want to kind of touch on some of maybe your practical tips for participating in mediation and how you can best prepare.
Whatever you think is most important.
All right. So a lot of us here represent large entities, maybe a pension fund on the plaintiff side, or a big Delaware corporation or alternative entity. Sometimes getting the decision maker in the room, virtually or physically, is difficult. Any tips that you have for litigators to come into mediation, making sure that we have that red line to the person or persons who can make the decision?
you're entirely right. You want to have people who can get the deal done. With that said, I've never seen the entire board of directors show up at a mediation
Unless they're getting sued.
either.
Right.
Even when they're being sued, they typically don't all show up at the same time.
Right.
So getting the whole board or the ultimate decision maker may be very challenging. You can, in the process of preparing for the mediation, you can do a lot of work to try to ameliorate that. So you can ask questions such as, who is coming? I want to be able to, I might have a discussion with you, Ryan. I want to tell opposing counsel who you're planning to attend,
right,
to make sure that we're getting, if you're bringing the Secretary of State, we want them to bring the Secretary of State. So let me tell them who you're planning to bring if you want to get the counterpart there. Another good question to ask is, in addition to simply asking what is the authority level, another good question is, the people who are coming, how often do the ultimate decision makers accept their recommendations? How persuasive are they? Or do they have direct communication with the board or the CEO or the chief financial officer or whoever is making the ultimate decision? These are important questions to ferret out before the mediation day, because we don't want there to be any surprises. We don't want you bringing the Secretary of State and the other side bringing the deputy assistant to the deputy Secretary of State. We have to bring that out in advance. We also, in terms of preparation, convincing people that the other side is coming in good faith. There are several indicia of that in addition to who they are bringing. Are they submitting a mediation brief? Is it well prepared? Are they exchanging it in advance? Are they traveling? When people are buying airplane tickets and going places, that's typically a sign that they're taking it seriously. They're not just bringing an empty suit all the way across the country. Simply the payment of mediation fees. Has the other side agreed to pay their half? Have you received their half of the fee?
Yeah, that's really important.
It shows that they've literally bought in to the process. So sure. There are many indicia of seriousness, and we look for the shadow of good faith and a lot of these other indicia.
Yeah, and like you said, the simple gesture of sharing with the other side and showing up goes a long way. It's one of the most frequent questions I get is, who's coming?
Mm-hmm.
They want to know.
Yes.
And so I will often ask, can I at least disclose that? If you're not willing to share your statements, can I at least share the people who'll be in the room?
Right, because this is the person to whom you want to tell your story. If you can tell your story to this person and it's persuasive, it will make a difference.
Mm-hmm. How about a mistake that litigators often make and that's readily solved? Anything that comes to mind?
Failure to prepare properly. After the briefs are exchanged, after we've had our phone calls or Zoom calls with the lawyers then need to go back and talk to their clients and say, here's the preliminary plan. It's like when you go into a hospital, if you need something done in a hospital, the good doctors will explain to you step by step in advance, here's what's going to happen. You're going to check in, you're going to go for these tests, we're going to have to wait a while here, etc. Similarly, if a lawyer explains to a client, here's what's likely to happen, we're going to spend some time by ourselves, we'll get together, the mediator does this, the mediator does that, that kind of preparation is very helpful. There's a mindset point, and this is another point articulated so well by Dr. Goulston. He said, Jeff, sometimes you have to remind people they're not there to prove a point. They're there to make a deal. If they want to prove a point, well, as you mentioned, you've got a lot of wonderful judges here in the state of Delaware, state and federal. You want to prove a point, go talk to one of them. You're here to make a deal. And sometimes I will have to admonish people or remind them that they should limit their comments to those things which will help move us in the direction of making a deal.
Right.
If they're there to prove a point, they're likely just to generate resistance and antagonism.
Yeah, I think that's right. And on the client side, sometimes those early meetings with them, you can have that cathartic moment where they can make the quote unquote point. Because oftentimes they haven't had their day in trial. They're itching to tell somebody else besides their attorney what grievances they've suffered or their view of what the other side said that they did. But that should be early.
Yeah.
And that should be weeded out by the time we start talking resolution.
That's right at the very beginning of the day. I like to have private meetings with the lawyers and their clients because whereas I've commonly met and worked with the lawyers before, less commonly have I met or worked with the clients before. So simply asking the clients, do you have any questions about what we're doing today? Many, many times, clients will say, no, not really. And then if you can simply impose the mental discipline to count to 5 without saying anything, and that's tough for lawyers, almost always the client will say, oh, but there is this one thing. And then when the client starts talking and you start to develop some rapport and some chemistry with the client at the beginning of the day, that pays off big time at the end of the day when the lawyer is enlisting your help to try to persuade the client to pay a little more or take a little less in order to receive all the other benefits of getting the darn thing done.
Right. And sometimes that takes a little bit of confidence as an litigator to allow your client to speak up. And, we don't let them speak necessarily in court unless they're on the witness stand, but mediation's a different animal.
And that too is a matter of preparation.
Right.
Because lawyers should talk to their clients beforehand. What are you thinking of saying?
Right.
And make sure that it's okay.
No, that's great. We'll wrap up just with maybe some of your thoughts on, hiring a mediator. What are some things that parties should take into consideration when selecting their mediator?
Selecting a mediator is a great black box for mediators. We never really know how the process works. One thing I can tell you is there's no one mediator who is right for every case. Sorry, Ryan, not you, not me. You could have Abraham Lincoln, Prophet Elijah. It wouldn't matter. It's not going to be the right mediator. There's no one human being who's the right mediator for every case. So there are, generally speaking, 3 things that I think you ought to think about. One is subject matter familiarity. How familiar does the mediator have to be with the subject matter? If you're dealing with the basic stuff of torts and contracts, civil procedure, well, we all suffered through the first year of law school. We all know that stuff pretty well. More specialized areas of some of the corporate governance, patent, bankruptcy, whatever, you may require more subject matter expertise. Your due diligence should certainly include that. Second point, mediation skill. Are you dealing with somebody who's really a student of the game? You guys are Delaware litigators. You're dealing with high-end, sophisticated corporate governance, intellectual property, insurance, bankruptcy issues. Do you have a really skilled mediator? It's very difficult to evaluate mediator skill. Is the person a good listener? How do you measure that? One helpful proxy, I think, is the mediator able to conduct a joint session in appropriate circumstances? If a mediator simply says, oh, I never do joint sessions, they never pay off with anything, that would be like a litigator saying, oh, I just never make a summary judgment motion. They never get granted. And you know what? I never oppose them either, because if they're granted, they always get reversed. Well, if a litigator said that litigator would not have very much work. And similarly, if a mediator says, well, I just don't do joint sessions, I don't know how to do them, the mediator, I think, is evidencing a lack of one essential skill. And then the third and final point is the personality of the mediator. Horses for courses. No one mediator is right for every case. A mediator who might really be able to get on wavelength with a particular client may be horribly unable to get on wavelength with a different client or a different opposing counsel or a different client of an opposing counsel. So this is why you should talk to mediators in advance, try to get a little taste of the mediator's personality to be able to assess whether the mediator will be able to get on wavelength with you, your client, opposing counsel, opposing party's client, to a reasonable degree. So those are the three things to take into account: subject matter knowledge, mediation skill, and personality.
No, that's great. We got 2 minutes. Does anybody have any questions before we wrap up for Jeff? So the question from our plaintiff's attorney in the back is, what was the contingent case and how big was the recovery?
We represented the founders of Guess Jeans, who were in a battle royal with the founders of Jordache Jeans back in the 1990s over the dominion over the blue denim universe. And there was a trade secrets case, confidential business information, fascinating, complicated grudge match. And it finally resolved, and every partner in the firm got about 4.5 years income at once. So the first thing I did actually was have a conversation with my CPA about the alternative minimum tax. And I realized, well, okay, I'm not retiring. back to work. And I just thank God that I found work as a mediator after that. It was one of the best decisions of my life to go into mediation. I just love the work.
So Peter, to your question, the question is opening bids and how successful are they? And I will tell you, when we have had the opportunity to have those pre-calls, right? A call with the litigators to exchange their views with each other, a call with you and your client so that I can say, hey, you heard Garrett's comments. What was your reaction to Garrett's positions? Sure. And I think Jeff's thoughts too. We are really mediating whether or not the clients realize it or not. So I do like to try, if we can, to get an opening bid coming into that day. That helps us begin to talk numbers and terms early in the day. But sometimes it's not possible. So I welcome it if it can happen. The other thing that I'm doing when I'm having those calls is, let's take a case where you've been through discovery. Maybe there was an early pre-litigation settlement offer. Maybe there was a mid-case settlement offer. Parties often have different views as to who should make the opening, the quote-unquote opening. Someone may feel that they opened and that they're not now being asked to bid against themselves. So I try to ferret that out through the conversation of saying, who feels like they need an offer? Will somebody be offended if I go to them and ask them to make the offer? I think in our corporate cases, as opposed to like a personal injury case, right, where there's the money's flowing definitively in one direction, it's really important to have those conversations so that I can ask sensibly as to who should make the offer. But the point of all that legwork ahead of time is so that when we come to mediate, we're talking terms sooner in the day rather than later. But Jeff, I don't know what you think.
Every case is different, and every case has to be weighed on its own individual circumstances. Recall that one of the things we do is we exchange information to a greater or lesser extent. And I find if we don't get initial demands and offers until after we're completed some exchange of information, then the opening numbers tend to be a little less extreme.
Mm-hmm.
Because we've had the opportunity to establish that calm, informed environment. And people may have come in under a full head of steam, but then they actually listen to what the folks on the other side have had to say, had some conversations with the mediator. People may say, well, I thought this was a gazillion-dollar case, or I thought I'd get out of here for $1.98, but now I realize maybe this is a little more of a horse race. Maybe that extreme number is not as appropriate.
Right.
Sometimes they want to make the extreme number anyway. And I'll say, typically in the etiquette of these things, the plaintiff goes first.
Mm-hmm.
Say, they want $1 gazillion. And I'll say, that's great. Let me ask you, how do you think the folks on the other side are going to react to that? And the plaintiff's lawyer is usually so happy with that question. And then as somebody will say, well, they're going to be very upset in the defense room. Jeff, do you think you can keep them here? Do you think I don't think they'll walk out. But with that kind of $1 gazillion demand, they're likely to come back with $1.98. Are you okay with that? And if the plaintiff side is okay with that, okay, everybody clears their throat, and then we get down to more serious bargaining.
Right.
Or if the plaintiff says, gee, I don't want them coming in with a $1.98 offer, then the question is, okay, what do you want to do in this room to try to have an effect on them so that they will start with perhaps a higher number?
Right.
And that's part of the psychology of the negotiation, the human factor. And that's what makes it so challenging, so stimulating, so interesting to do this kind of work. And that's what makes it such a pleasure and a joy to be able to do this kind of work with sophisticated lawyers like you every day of the week.
Yeah. And Peter, just to follow up on that, I think it's difficult when we have counterclaims because you have two sets of plaintiffs. And even when we try to convince people to parties to come with a more objective offer, oftentimes that first offer is that cathartic sticking it to them. If you've mediated with me, you've heard me say, okay, we got it out of our system. Now let's start talking, right? Kind of getting to what Jeff is talking about.
Yeah.
Well, anyway, we'll have to get back to work. Thank you very much for joining us. I hope breakfast was enjoyable. I hope you got to see some faces. Wish everybody happy holidays. There's a CLE form on the table. We'll get you an hour of credit. We'll get that submitted. So again, thank you to Jeff. And one final plug for Jeff. Every Thursday, Jeff does a video on YouTube about mediation practices. I highly recommend you look at that. He only asks for, a voluntary donation. But Jeff, for coming to Delaware and gracing us with your thoughts and expertise, our firm will be making a donation to a food bank. Jeff he asked you to donate to a local food bank, and what better thing to do at this time of year? So thank you for that, and we appreciate it.
That's beautiful. It's a pleasure being here with all of you. Thank you all very much. Ryan, to you, to your firm, the wonderful business development and marketing team, the audiovisual capabilities, wonderful folks here at the Wilmington Club, and most of all, to all of you for taking time from your busy schedules to be here. Thank you all very much.